Yes, sir.
Thank you, Your Honor. I'm the petitioner, David Toulis, and this case is about legal fundamentals. The rules of statutory construction are at the center. This is a law case. There are no facts in dispute. And the main question is, what is the meaning of certification and verification? There are two main dispositive grounds that I've put into my petition. And the question in the largest sense is a billfold card or a policy page of an insurance company proof of financial responsibility, or also called POFR. It's a question of sufficiency, and I'm challenging the operation of the Department of Revenue's electronic insurance verification system. Certify, in most general terms, means to guarantee as proof, generate certainty or the absence of doubt. Blacks says it's a ticket or a warrant constituting, quote, evidence of truth of the facts stated therein, unquote. A certified document is more secure than another document. It has a higher validity. It is more meriting in trust. It has behind it authority. And so the question is about the motor vehicle liability policy that is the center of the statute, which is 5512-101 at SEEK and also 201 at SEEK. The question is, do TFRL and Atwood Amendment compel 100% of registrants of motor vehicles, such as me, to buy insurance or to show proof of financial responsibility? Is EVIS being run under the law? The purpose of EVIS is at 5512-202, and it says that the purpose of that amendment, the Atwood Amendment, is to develop and implement, quote, an efficient insurance verification program to verify whether the financial responsibility requirements of this chapter, Chapter 12, have been met with a motor vehicle liability policy. The department gives registrants three choices on how to meet the policy that they've put forth. You can buy a bond, they say, but bonds are not available. I have tried to buy one. There's an affidavit in the record showing that I could not obtain a forward-looking bond for a privately used automobile or motor vehicle. They say also in the department that you can pay $65,000 to the commissioner per vehicle that you use on the public road. The third option, which I can't afford, the third option is that you buy insurance that's not certified, that you buy an insurance policy not certified, which for personal reasons I have not been able to do. The department uses EVIS, EIVS, to surveil all auto policies. It matches VINs, vehicle identification numbers, and policies. It creates a non-customer list. They're called unconfirmed parties. And it targets more than 1 million non-customers of the insurance business. It's more than 1 million people who do not have insurance. And every week, the department, using a contractor, sends out 12,000 notices by U.S. first class mail, 6,000 on Monday, and 6,000 every Wednesday. It holds, the position is this. And I'm holding in my hand two documents. The one on your left is just a standard form of a billfold wallet of one of the cars I had insured, and it has no language, neither the underlying policy, any language saying that it complies with the Tennessee financial responsibility law. On your right hand, Your Honor, there is the SR-22 form. This is the form that certifies the policy that certain people have to purchase to maintain the privilege. They cannot keep the privilege unless they buy insurance with the insurer issuing this document. It's called the Financial Responsibility Form at the top, SR-22, and it also calls itself the Financial Responsibility Insurance Certificate, and you have copies of this in your in the pleadings that I've entered into the case. It runs a program that it says is independent from and parallel to the duties that are fulfilled by the Department of Safety. However, the Department of Safety is in charge of the entire chapter. In 103, we're told that the Commissioner of Safety shall, quote, administer and enforce this chapter. Should the respondent be free to continue using EVIS under the certification that the Commissioner of Revenue gave when it began operation January 1, 2017? That's under 212. Section 212 is his requirement to certify the use of this tower, this surveillance tower, into the databases of insurance companies. Or do the fruits of this, quote, independent program, unquote, which I would say are 28 abrogations of law, do the fruits provide grounds for the court to order the use of this system that began operation January 1, 2017 to be decertified? The commissioner says to the first question, yes, continue the operation. The petitioner says, no, the rules of statutory construction forbid it to continue as a matter of law. Section 214 in the Atwood law, the Atwood Amendment, forbids altering, quote, existing financial requirements in this chapter. That is a very stern warning at the end of the 15 sections of the Atwood Amendment. The certification issue starts, as I'm defending it, with the definition of motor vehicle liability policy. That is in section 102, paragraph 7, and it says a motor vehicle liability policy means an owner's or operator's policy of liability insurance certified as provided in 55-12-120 or 55-12-121 as proof of financial responsibility. So the definition of the policies in view in the law that the law controls and regulates and creates is that it is certified. The respondents ignore the black letter law for a wicked and degenerate, ungodly and unconstitutional purpose. And I have it from their own lips. Christine Lapps is the Deputy Commissioner of Revenue, and she says in one of her orders against my cause in the record at page 1164, she says that the definition of financial responsibility, quote, is a term that refers to the registrant's established capacity to recompense injury or damage sustained in an accident, unquote. Again, that's 1164. The hearing officer with whom I dealt for almost 2 years in the department, Brad Buchanan, says it is the intent of the General Assembly in enacting the TFRL to bar such motorists from operating on the highways of this state. That is an unconstitutional purpose, denying equal protection to 1/7 of the population who are registered. Because that's we have 6 million registered vehicles and 1 million of people who are out of compliance with the program run by the respondent. Section 114 in the TFRL on suspension or revocation of registration and POFR says that when safety suspends a license on a conviction, it, quote, shall request, unquote, the respondent to suspend all registrations in the person's name. But, however, there's a but not if, quote, the person provides and maintains POFR for the length of the license's revocation or suspension. Formerly, the law changed at the end of 2023. Formerly, it said 3 years. So the length was now in the statute as length of suspension was formerly 3 years. The earlier version of the law had also a 5-year duration lower down in that provision until release by safety. 5512.114E refers to the release of the requirement for proof of financial responsibility, showing, among other things, that there's no continual duty for POFR, even of a high-risk SR22 driver formerly who has made good, who has paid his price, he has gone under effective probation by the Department of Safety to carry this special insurance that is certified. The wording on the certificate, financial responsibility certificate, I think is very helpful, and that's not made up. That is, this form is approved by the Commissioner of Safety, and it's also repeated in section 126, showing what the SR22 is about. This is the SR22 form I'm holding in my hand on your right side, sir, and it is industry standard under the IICMVA, the regulatory body for that trade, and again accepted by safety. 119, section 119, is about the manner of proof. Quote, POFR, when required under this chapter, may be given by filing, 1, a certificate of insurance as provided by 5512.120. Notice the word when required. It's not required of all, it's required of some. Section 120 says how the proof operates. It says POFR may be furnished by filing with the Commissioner of Safety, quote, the written certificate of any insurance carrier duly authorized in this state, certifying, and again the key word is certifying, that there is in effect a motor vehicle liability policy for the benefit of the person for the benefit of the person required to furnish proof of financial responsibility. Section 121, again, we're tracking down the certificate issue regarding this section, non-resident certificate. A non-resident can show proof of financial responsibility by filing with safety a, quote, written certificate or certificates, plural, of an insurance carrier in the state, unquote, in the state where the vehicle is registered. The carrier agrees, quote, in writing that the policy conforms, quote, with the laws of this state relating to the terms of motor vehicle liability policies issued therein. And 122 says, regarding the contents of these special policies, they can't be canceled. They cannot be canceled. The law describes owner's policies that can be certified and also operator's policies. Owner's policies connect to a vehicle, and as you see on the form, Your Honor, this list right here is for people who buy the owner's policy and they put in their vehicles for protection. The operator's policy covers the insured in any vehicle he's using, in any vehicle, without any VIN being attached to the policy. The certificate is at the center of this law, and we have it on the authority of McManus versus State Farm Mutual Auto Insurance Company, 1971 case, 463 Southwest 2nd, 702, that the filing and approval by the Commissioner of Insurance and Banking of a motor vehicle policy does not make it a, quote, certified policy under the financial responsibility statute. Section 123 regarding cancellation and termination repeats the material earlier and says that the motor vehicle liability policy, quote, shall not be canceled, unquote, without a 10-day, quote, notice of cancellation or termination of the insurance so certified. So this is a requirement between the Commissioner of Safety and the insurer that didn't occur in my case as far as I know. There was no notice given when I stopped paying for my Honda Odyssey minivan, the vehicle that gives me standing in this case. When insurance dropped, or should I say, when I dropped insurance, no notice was sent that I'm aware of to the Commissioner of Safety. The authorities that the respondent is relying on for this program are largely two, Section 139 and Section 210. The initial wording in 139 is of special interest to the court. The initial version of the statute that was voted on in 2001 and took effect in 2002 says, quote, every vehicle driven on the highway of this state must be in compliance with the financial responsibility law, unquote. That was changed because there were people running vehicles that were not necessarily road vehicles. It was changed to account for that, and the new version that's current says 139A, quote, this part shall apply to every vehicle subject to the registration and certification of title or certificate of title provisions. That's the 2005 amendment. The word this part, I think if you're going to look into the rules of construction, this part is very important. And under the rule ad justum generis that controls the reading of this provision, this part controls what 139 means. When it refers to this part, that's talking about part one, because we have part one and part two and part three. Part one, this part, controls what 139 means. These first two words refer to sections 101 all the way through section 138. So what's happening in those provisions controls the meaning of 139 when you're reading in paramateria. The rule ad justum generis, as you certainly have come across as a judge, Your Honor, says that a narrower provision in a statute controls and limits the broader, more general terms. The more general term in this instance is this part shall apply to every vehicle subject to. This law is not talking about all vehicles. The word vehicle is already prescribed and narrowed by the nature and scope of the duties imposed by this law in the context of qualifying accidents and also suspensions of privilege and the party seeking to maintain the privilege for the necessities of life, making agreement to buy insurance to secure the public interest and the public safety. 139 does not change the scope of Part 1 as alleged to every motor vehicle. 139B2A regarding documentation says that the state policy, quote, meets the requirements of this part. So 139 has language in it that refers to the other parts, again, limiting the operation of that first sentence in paragraph A. The requirements are of 139 that you have to comply with the statute if you have a qualifying accident, which is $1,500 or more. And when you have that qualifying accident, you have to give report to the Commissioner of Safety within 20 days. And the other requirement is the after judgment conditional use of the privilege. That's what's in view in 139. So 139 doesn't overthrow the TFRL as the other side would like the court to believe. 139B2B letter I, or letter 1, small letter 1, regarding cash deposit or bond in the amount required by this part has been paid or required by this part has been paid or filed with the Commissioner of Revenue. Well, if proof of financial responsibility, sir, can be established by the amount of damages that satisfies the law, and you have bought a bond to cover the part that you're responsible for, and you have a certificate for 1 year of that payment in that accident, we're dealing with a qualified accident here, then you are satisfying the law. The question the court should ask of the other side is, how are people who are satisfying the law revoked by your department? 210 is the other main authority that the Department of Safety is using to run this arbitrary and capricious program. This statute is the protocol on notices that go out. There are 4. I received all 4 of them in my revocation in 2023. But even here, we have their position undermined by phrases such as insurer of record. The insurer of record is the one that issued the certificate of financial responsibility insurance. That 210 goes on to say that if the vehicle is no longer insured, the owner becomes eligible for notice. You become eligible for notice when having a duty to have the special insurance, you don't have it. You're not paying the dividend, you're not paying the premium, and the notice goes out. DOR says the word in 210, the word shall, shows a duty to every owner to be insured. That's 210A1. And it says, quote, DOR, or the Department of Revenue, shall provide notice to the owner. Well, in Mr. Buchanan's 62-page order against this cause, he says that word clearly shows that if the department has a duty to send a notice, you have a duty to receive it, and you're the subject. So in other words, he's turning a kind of technical procedural provision into a liability provision, which is not proper. It also claims that 210's reference to motor vehicle, again, means any motor vehicle. The department is not construing the terminology narrowly in 210, but broadly. See, motor vehicle, you have a motor vehicle, therefore you are liable for performance. The summary of the certificate part of my case, Your Honor, is that 139 and 210 do not create any new powers. From the original act, Atwood merely secures better compliance. The original act is a financial responsibility law, not a mandatory insurance law, and that has not changed under 139 despite efforts to convince me and convince the court that the legislative history did that. The law is not a mandatory universal insurance law. The second dispositive issue in the complaint and also in the motion for injunction, which I'm asking for, is denial of due process, and that is that the case that is in the record in the court is void. It's a void case because the hearing officer and his court have or had no subject matter jurisdiction. Safety oversees TFRL. 103 says that the commissioner shall administer and enforce this chapter. 104, section 104, on suspension notices says that the citizen is, quote, entitled to an administrative hearing, unquote, in safety. 103 begins with very interesting exceptions language. It says, except as otherwise specifically provided, the commissioner does these things to manage Chapter 12. Except as otherwise specifically provided, he shall enforce and administer. That's the sentence. The department is offering a workaround theory that this case rises from the tax law in 67-1-105. But the tax law in that provision has the similar language. It says, in the absence of any other provision, in one phrase, and then also, except as may otherwise be provided by law. If TFRL hearings are in safety, clearly we have three evidences in statutory language that the hearing officer had no subject matter jurisdiction because the entire dispute has to be heard in safety. And also, 67-1-105 has this, that the hearing under that title has to be heard before the revocation because it makes reference to proposed revocation of license or privilege. If truly Commissioner Gargano is using that law, well, how come he didn't give me a hearing beforehand? There was no provision for a hearing beforehand. Thus, my due process rights are violated that way, and also the fact that I have been in this Bermuda Triangle court where things just disappear, they turn into vapors for nearly 2 years. And I've provided the court with cases indicating that consent, participation, filings in a court with no subject matter jurisdiction are void. There's no way around it. There's nothing. My being there doesn't validate that body. The other side's position, since it is a road program with 28 abrogations cited in my brief in support of the motion for summary judgment in the agency. 42 pages. I have 28 abrogations of law. I've gone through the whole thing like a good journalist should. Nothing's left. There may be some that I missed, but I've accounted for 28. Some of them are being mentioned here. You have maddening contradictions that should give the court pause when the other side asks that you accept the certification of the January 1, 2017 operation of EVAs, that you accept it, that it's solid, that there are no doubts, that there's no lack of certainty about its proper lawful operation. Section 106 of the TFRL gives 15 exceptions. Number 13 applies to me, and that exception deals with when there's no contact with anybody else. It's an exception, but that's denied. It's denied by revenue. It is unlawful in 130 for the Commissioner of Revenue to re-register a motor vehicle without the express written permission of the Department of Safety Commissioner. It's unlawful. And yet Ms. Landfair, the witness, said that, well, that's not a problem. He can do that because the program, not that she said this, but the program as defended in the courts is independent and runs parallel to the TFRL. And what about the question of release of the obligation? I've mentioned that already, but specifically, there are 5 provisions of the law that mention release and talk about release of the requirement for POFR. There's 114, 116, 117, 125, and 126, all talking about release of the obligation. And yet, DOR says it's perpetual. Your obligation to have insurance is perpetual. There's no way around it. So you can be freed after 3 years under the probation, effectively, of revenue on your license. You've paid the policy time, and the first day that you don't have insurance, these people are going to revoke. They're going to start sending you notices because you've shown up on EVAs. Other maddening contradictions would be this: certified is the same as non-certified. Would Mr. Barca, the attorney for the commissioner, accept getting an email from the registrar's office after he worked so hard to get his law degree saying, Nick, you've graduated? No, he would not accept it. He wants it certified. He wants a certificate embossed in gold on fine paper that has the authority of the school he got his degree from, put forth proudly with integrity and honor, not just an email from the registrar saying you're done. Okay, that's not going to work. Department of Safety controls suspensions, and yet here, because every suspension is under notice or request from the commissioner, and yet we have the Commissioner of Revenue just suspending people left and right. Mrs. Lapps, Commissioner Lapps, talks about giving the law a plain reading. And I think that's also kind of language discussed by or offered by Mr. Buchanan. And then the commissioner's deputy says also, in contradiction to her own statement, that certified is not defined for the purposes of Chapter 12. So which is it? 214 forbids altering the requirements, and yet the respondent has altered the requirements of the law, which is again about the motor vehicle liability policy. I have a very good record as a driver, but I'm presumed to be a bad driver. I'm treated as if I were a bad and irresponsible driver. We have 2 departments. The hands of the commissioner are on the steering wheel, and we have the Commissioner of Revenue grabbing that wheel and wanting to go his own way. And that's what he's done. The independent and parallel analysis and argument claimed by the respondent, I would say, is an admission and is proven by the abrogations that I have listed. The eye of Sauron is an optic. It's supposed to work like this, like a set of eyeglasses that I'm holding here in my formerly newsprint ink-stained fingertip. Glasses are calibrated to the optic problem of the user. They fit, everything is clear. But what we have, Your Honor, is this. We have the eye of Sauron run by the department, and this picture is from the Lord of the Rings literary and Hollywood franchise. That's what we have burning out the landscape. When I say burning out the landscape, I'm not just speaking figuratively, sir. We have 40,832 criminal convictions per year. That's based on reports given by the two commissioners, and one of these is in the record. This is a letter from Garagano and Jeff Long, the Commissioner of Safety, the 2023 letter, saying what the success is of the program. And eight of these numbers come up with 40,832 criminal convictions per year on the average. Now, some of these people may truly be SR-22 privilege holders who have failed to do what they agreed to. No doubt there are some, but the majority, I'm going to suggest the majority, are innocent people like me. The Department of Revenue requires the purchase of insurance policies that are legally insufficient to be POFR. Good drivers and their insurance, if they have it, is of no concern in the statute to EVIS or to the Department of Revenue. They are not to be surveilled. Motor vehicle liability policies are for, as I say, probationers, people who are subject to the proper coercive power of the state through the privilege system, which licenses the commercial use of the roads. And if they're going to have that privilege, they'd better be safe, and they'd better, if they cause an accident and have a liability for an accident, they'd better make good. The injunction I'm asking for has three requests. One is decertification. Number two, the order ending the mailouts, and I've drafted an order for you to consider, sir. And then the third one is provisional use until the litigation is completed of the tag on my car. I believe that there is the certainty of success, which is something I've argued for in my petition for the injunction. The law is very, very clear. I'm relying on the infrastructure of our legal system to make my claims. There is no harm to DOR in compliance with the statute. It's supposed to obey the statute. There cannot be harm to it, I would say, by conception or a priori. It's not possible that compliance with the statute injures that entity or body in any way, or the state. And I also give space in my motion for irreparable continuing harm. That's in my affidavit supporting the injunction. I'm denied two non-disjunctive rights. I have a right to commerce under the tag. I can't do that now. I cannot drive and operate my motor vehicle. The act of driving and operating my motor vehicle implicitly and necessarily is commercial under the privilege. Now, the privilege system is best described in the case Phillips versus Lewis, and that's also in the record. I have, I believe, a copy of the whole case and maybe some excerpts, but privilege is for privileged taxable activity, and I'm denied that right in my car. Continuing, I'm also denied my private use of my Honda Odyssey minivan as an automobile. Buchanan does not recognize that right. Neither does Christine Lapps. They do not recognize the right of private use. Then they cite State versus Booher, which has a kind of a trick sentence in it. So my harm is continuing. I'm facing the threat of arrest. I have in the record a safety letter that was given to me while revenue attorney Camille Klein had a baby. And I said, well, it's not right to hold up this case while she has a baby and I'm exposed in my use of my car. That's not proper. So they gave me a letter. Why? Knowing that their privies will arrest me for a revoked tag or a suspended tag. They will prosecute me. It's already happened. I've been criminally charged here by Hamilton County for being on press business in my in a RAV4. So we know that they believe it proper to use criminal police power on what are administrative allegations. And this is because police, deputies, and troopers do not respect the limits and do not believe in the nature of privilege, don't understand the nature of privilege. They use criminal police authority as if a tag suspended is a crime. That's what they'll do. They'll criminally charge me and arrest me. However, I have rights that they ignore, and I'll just briefly mention those, and that would be these, that under privilege, hearings on allegations of misuse of the privilege are in the Department of Safety. And the doctrines that make that happen are that under Colonial Pipeline versus Morgan, the exhaustion of administrative remedies. All privileges are managed by the commissioner or the board that's responsible for the license. And no cop or deputy or trooper respects that. They will criminally prosecute me. They won't say, Mr. Toulis, we think you've been driving and operating your van. We're going to send a memo to Commissioner Long about that, because that's what they can do. But they can't criminally charge me. So they're avoiding my due process rights to have an administrative hearing before criminal enforcement. So that's why I'm being harmed. And finally, on the injunction test, the public interest, I would say that given we have such a large number of errant, mislaid and misfiled, misfired criminal prosecutions, it's proper to issue the injunction. Mrs. Lapps talks about established capacity. What she's saying is that if you're poor, you can't use the road. That's not a proper cause. It violates due process and equal protection under the 14th Amendment. We don't have speech insurance. You can't talk unless you get a policy. You can't copulate and have a baby if you don't get an insurance policy for the child that issues from that. There's no birth insurance. We have a presumption of liberty that I'm asking the court to defend. This case empowers this court to protect that presumption. We're free moral agents. We don't need supervision. We don't need the line separating liberty and security to be moved towards security, which apparently is what's happened. We move that line towards security, keep poor people off the road. Now we're all safe. We're all secure. That department cannot legislate as it is doing now in violation of the division of powers. Only if we show ourselves, or only if I show myself as the petitioner as irresponsible or having harmed someone without making account, only then, in the moral nature of our universe, am I liable to be subject to safety first, and then if I continue contumaciously to not cooperate, only then by the Commissioner of Revenue. But there's no presumption of wrongdoing. Wealth does not equal responsibility. That's the claim that these people are making. Wealth, if you're wealthy or middle class, you're responsible. If you're poor, you're irresponsible. That's not lawful in any way. There has to be a presumption of innocence, and that presumption can be satisfied legally by Revenue by having him look in the DOSHS driver records. That's on the back of the driver license application. It says essentially that a good driving record is your POFR. If you're a good driver, you are showing yourself responsible. The roads, Your Honor, belong to the people. They do not belong to the commissioner. They do not belong to the department. The highways of the state belong to the people of the state. That's from Dunlap versus Dixie Greyhound Lines, 178, Tennessee, 532. It's a 1942 case. Again, the quote with about 3 sentences says, the highways of the state belong to the people of the state. Many of these highways have been improved at large cost to the taxpayers. It is the convenience and necessity of the people of the state that must be given predominant consideration by the commission, and not that of contending motor carriers operating free over the highways. That's my presentation, Your Honor. Will I have occasion to respond after Mr. Barker?
Yes. I have a question.
Yes, sir. Please go ahead.
This, this notion about the wrong agency. Okay.
Not really.
This notion that you say the wrong agency rendered the decision in this case, and therefore there was no jurisdiction for that agency to render that decision. Did you make that argument in the agency?
I did. I argued that I challenged the subject matter jurisdiction, but when the movement challenges subject matter jurisdiction, he can dismiss his own case. And that's what Mr. Buchanan invited me to do. He said, well, you can dismiss your own case. I pointed out these things about the duty of the commissioner to hold hearings, the inefficacy of Title 67 as the basis, the lawful basis for the hearing. And I said, you know, this is not proper. And so I did bring that up. But a challenge to subject matter jurisdiction can be brought up, you know, while the finger of the executioner is on, just about to touch the red button. Right? It can be brought up at any time. And I did bring that up. And please, I would be glad if you ask me any questions about what I'm saying, sir.
I just have another question.
Oh, yes, sir.
Based on that answer. Did the agency decision that you received, did the decision address your argument in such a manner as to say, we know you made this argument, but we reject it, and give the reasons why?
That's a good question about the order, the 62-page order by Buchanan. Don't remember if he addressed it exactly, but the defense has been Title 67, Section 1, 105. That's been the basis of the case.
Okay.
And the hearing.
Okay. I may have more questions for you later, if
Yes,
you don't mind.
Thank you very much, sir.
We'll let Mr. Barker talk now.
Thank you, sir.
Yes, sir.